practitioners gathered here today who will present to you different topics. I will make it very brief. I'll try to be brief also throughout the webinar. I will guide you through the webinar and will introduce to you the speakers and the topics very briefly. We will start our seminar today with an overview of sanctions and the sanctions lawmaking of the European Union. And this topic will be presented to us by Mareike Heesing and Christoph Oertel. Very briefly to these speakers. Mareike is a junior partner at the German law firm Oppenhoff. She advises on foreign investment control procedures, export control, and sanctions. She has particular expertise generally in public law and has been also as such recognized with the Best Lawyers Wants to Watch Award in 2023. She's a German-French law qualified and heads also Oppenhoff's French desk. Christoph Oertel is a partner at the German law firm Brödermann, Jahn. Christoph advises on international business projects, on transactions and international and national trade law. He has a focus on compliance and as such, of course, also advises on export control laws. And he's currently the president of the UIA's Contract Law Commission. So very high profile speakers. Thank you for being available. We look forward to hearing from you now. The floor is yours.
Yes, thank you very much. I will have the honor to introduce you to economic sanctions in the EU. I will be very brief, not taking much more than 5 to 7 minutes in order to give all speakers the time to tell you about the effects of those sanctions, which I will introduce you now to. Next slide, please. When we talk about a company that is subject to sanctions, you must be aware that there is not only one set of sanctions all over the world, but in theory, every country can enact its own set of sanctions. For companies that are located in the EU, and in my case in Germany, the EU set of rules, and in some very limited cases, there might be extra German laws that might be applicable directly to those German or EU countries. But as a matter of fact, companies who deal in international trade, they must take into account at least sanctions from other countries, in particular the US, UK, Canada, Australia, Japan, and other countries where they have business into, not that they are subject to these laws by law, but they can be sanctioned under the rules of these countries. The problem is that these international sanctions regimes are often not harmonized. They are often harmonized, but they are sometimes differing in scope, and this creates some problems. So if we go to the next slide, talking for the EU, where do sanctions come from? Often the UN Security Council resolves sanctions against specific countries, and these sanctions are then put into law by the EU through decisions of the common foreign and security policies, and then they are put into a regulation of the EU, which is then directly applicable to private law entities in the EU. However, not only resolutions of UN Security Council are put into sanctions, sometimes there are autonomous EU extensions of those Security Council resolutions. And sometimes, and this is the case for Russia, the EU enacts autonomous sanctions against countries. As I said, this is the case for Russia. So next slide, please. If the EU enacts a sanctions regime, it has some kind of a toolkit or a construction kit for economic sanctions composed of specific standard measures. Those standard measures can be divided into 3 or 4 groups. There are embargoes on the exportation of weapons and dual-use goods. There are export or import restrictions on economically relevant goods for the economy of the sanctioned countries. On the personal level, people get listed by standard measures, and that means that it is prohibited for EU economic actors to transact with these people. And there are, as a 4th pillar, sanctions related to financials and services in general. These standard measures can be found very often in sanctions regimes. However, there are also atypical sanctions. Example, in Russia, road transport is prohibited for Russian companies. Takeoff and landing of Russian aircraft in the EU is prohibited. And some banks are excluded from the SWIFT system. These are more atypical sanctions. If we go to the next slide, we find that the embargo on arms and dual-use items, meaning items which can be used both for civil and military goals, is the most common sanctions which we encounter. But embargoes can further relate to any other kind of goods and services, and they restrict the export or import of those sanctions goods. These sanctions goods are usually, and this is a very important source of information, listed in annexes to the European regulations. And the term goods includes not only physical goods, but also technology and software. So this, the applying lawyer must be aware of, that goods is not just physical, but also technology and software. The purpose of those weapon embargoes and sanctions on goods is to weaken the economy of the targeted country and encourage it to comply with certain standards. Next slide, please. So if we go to Russia, we have those 9 packages, and we can see that the goods which are subject to sanctions besides arms and dual-use goods are very varied. They vary from the steel and oil industry to luxury products. It's prohibited to import or to export luxury goods to Russia when the value of the good is more than 300 euros. And industry and technologies are also sanctions. You can see a list of examples, which is not exhaustive, but it is very broad, and each lawyer must be able to look into these annexes if it gives advice to companies that ask whether they can export specific goods to Russia or not. Next slide, please. The tricky thing about these sanctions in Russia is that it is not only prohibited to import goods that are physically located in Russia or that originate from Russia into the European Union, but the texts are as well designed in a way that it is even prohibited for EU companies to trade in goods which originate from other countries and which are physically located, for instance, in Syria or in Turkey, to another third country, because it's also often prohibited to broker the trade of these goods if they are originating in Russia. So the aim and the goal of these sanctions on goods is really to cut those sanctions goods for European countries from international trade. We can skip the next slide, please, because it just explains in the text what I've just said. explains the brokering services. Now, if you have already existing contracts, people always ask, what can I do with these contracts? Am I allowed to perform these contracts, or shall I refrain from performing these contracts? The EU has a set of rules that says that if you comply with a sanction under an existing contract, you are not liable towards your Russian partner. He can make no claims against you for non-compliance. And in some cases, so-called grandfather clause provide for an exception that specific contracts which have been concluded can still be fulfilled until a specific cutoff date, so that the trust in a good performance for the European companies is still granted. Next slide, please. When it comes to the sanctioning of people, there are financial restrictive measures that are often enacted. It means that of listed people, their funds are frozen. It is prohibited to make available money or funds to them. And next slide, please. One of the things to remember is that, please click further because it's prohibited that not only directly to those persons, but also to non-listed person when those persons are owned by a listed person or entity, or controlled by a designated person or entity. So this means that you have a high and intense obligation of researching who you are trading with if such trades come close to sanctioned situations. Next slide, please. And then in the last place, we have sanctions related to services. The Russia-related sanctions have a very broad scope. There's the prohibition to provide technical assistance and financial services for military goods, prohibited financial services, including providing cash money. It's the exclusion from the SWIFT system. Please go on. You are not allowed to provide credit-rated services. And for us lawyers, interesting, EU currently prohibits at least business lawyers, there are some exceptions, but to provide also legal advice to Russian entities if it's not for specific cases that are specifically enumerated in the regulation. There are some more services that are sanctioned in the Russia-related sanctions. And this is basically, in a very quick way, like how those sanctions are designed and how they can function. And I pass over the floor to Mareike, who will tell you about the problems and how those sanctions work when they are so dynamic in their scope of application. Thank you very much.
Thank you, Christoph, for this very helpful first overview. As you could see, it's a very broad scope of sanctions. It's one of the biggest, of the widest scopes of sanctions we have known so far from the European perspective. And another complexity that is added is the dynamics of the sanctions, as just mentioned by Christoph. Maybe you could go to the first slide, please. I would like to talk to you today about the challenges that are faced in the framework of this dynamic sanctions, because the legislative process is very, it's usually very well regulated, and the rule of law imposes on European legislation that laws and regulations must be clear, published, stable, fair, and protect human rights. And the process for the adoption and renewal of such sanctions regimes is very well defined in the European framework, deciding on various different bodies that take part in these decision makings. And you could see in the framework of the Russia sanctions, in which sometimes there were new sanctions released in the beginning, even on a weekly basis, that this process was speeded up significantly. And then moreover, the Commission, which oversees the implementation by the member states of the regulation, also was included in the process and tried to provide some additional assistance, which I will talk about in just a second. But this entire process was very much sped up due to the conflict situation, and this leads to the fact that the laws and regulations that were released are in some cases unfortunately not as clear as they should be. And so I would like to talk to you today about this phenomenon in the context of the energy sector. For once, because it's one of the sectors which was very highly, very intensely sanctioned in the framework of the Russia sanctions, and because it's one of the cases where the dynamics and the complexity can be very well seen. So talking about the energy sector, what is actually sanctioned in the sector? I just listed it briefly. It's there are sanctions regarding the purchase of the import of certain energy-related goods, the price cap, which we are talking about at the moment, which is currently also being discussed for the 10th round of sanctions, which is currently under discussion and to be expected probably soon. So there might be even further restrictions concerning the price cap. There are also other prohibitions regarding exports of goods related to the energy sector and new investments. And one of the prohibitions which I would like to talk today more in detail about is the prohibition to transfer energy-related goods with Russian origin or exported from Russia. It's a prohibition which is mostly regulated in Article 3J of the regulation 833/214. This is one of, this is the most important goods-related embargo provision regulation regarding the Russia sanctions. And in this paragraph, in the para 1, in the Article 3J para 1, there is a prohibition to purchase, import, or transfer directly or indirectly coal or other fossil fuels if they originate in Russia or are exported from Russia. And in the wording you can see it includes this prohibition to transfer such goods. And then you can read further on and it says, as listed in Annex 22, into the Union. And this is one part of the provision that I would like to draw your attention to, because this is also basically the wording that causes most confusion and most discussions amongst member states and amongst participants in the economy, companies who are dealing in this sector, because it led to a lot of uncertainty, which I would like to talk to you today about. So you can see this is just one example of how the provision would look like. You can see that there's always the annex, which includes the list-based embargo of the goods. So whenever you have certain goods, you can reference or have a look at the CN code, which is listed in the annex, and see whether your client's goods will actually fall under the respective prohibitions. In this case, coal was one of the items which was listed and is therefore subject to this embargo. And so the question was, regarding this transfer prohibition, whilst, regarding the prohibition of importing such coal into the EU, that is a fairly clear statement and a prohibition that everybody could understand rather easily. The question arose, what happens to coal with an origin in Russia that is being transported in an area outside of the EU? So just as the brokering prohibition Christoph talked about earlier, what happens if I don't want to import it into the EU, I just want to handle or transport these goods from Russia to a third country outside of Europe. And so especially in the maritime transport business, this led to a lot of questions. Is the provision even applicable to this transfer, to this transport out of the EU? And in this framework, you can well see one of the methodologies that the EU has been adopting in the framework of the sanctions, which is the instrument of FAQs, frequently asked questions. That is something that a lot of colleagues from countries cite, case law countries, when we work with laws and books and regulations. At least in the EU, many of our countries, we are not very used to working with FAQs, whereas in the USA that is a common instrument from authorities. But in the EU, it's something that was really rather new to us. And so the Russia sanctions regime was the first one where it really started working with FAQs and the challenges that come with it. Because due to the dynamics of the regulations, it doesn't include as many definitions as one might hope for, which is the reason why the EU Commission, as the body, supervising the implementation of the sanctions, has issued today 348 pages of FAQs on the sanctions regime only regarding Russia. In addition, there are some national authorities also releasing FAQs on a regular basis, and there is the challenge are not always coherent with the ones from the EU. The issue is therefore, or there are several issues related there too. The FAQs change on a regular basis. They are not legally binding. So in the end of the day, any prosecution that might be taking place due to sanctions violations is always part of the sovereignty of the EU member states, and therefore at the end of the day it will be a national EU member state judge who will be deciding on the case. EU FAQ are of course taken into consideration, but as such they are not legally binding. So what happens if, such as it was the case in the framework of the transfer prohibition, what happens if I have a change of FAQs, and if I maybe even have national authorities who might not be in the same opinion as is the EU Commission. Regarding the transfer prohibition, this was rather interesting, because in August 2022 the Commission stated that clearly the prohibition on transfer applied irrespective of the final destination of the goods, which would mean as long as it's US Russian origin, it doesn't matter where you would like to transport it. Even third country destinations would be subject to this prohibition. Then, just a month later, the Commission kind of went back on its initial response and said, we do see that there are some impact on food and energy security, and therefore we want to allow transfer to third countries of such goods, and coal was included, for example, in those goods, to combat food and energy insecurities. Here again, the country list wasn't defined, and so shipment companies were rather surprised when in August they clearly decided, we have an issue here, we cannot transport them, at least in the opinion of the EU, whereas then in September everything was changed back again. And then you would of course wonder, what do we do? What do you consult on? And you would have a look at the wording where you still have the reference to into the EU part. And so a lot of discussion arose, and even national authorities stated that they were of the opinion that the Commission's FAQ were not entirely convincing given the wording of the regulation. However, they decided not to issue any deviating FAQ, as was the case, for example, for a question of accumulation of minority shareholders, which is one of the issues in financial
signature. Yeah. Hier tekenen en
and then you had the issue, then German prosecutors even started prosecuting cases of transport of such goods, but decided then not to pursue those prosecutions on the grounds of a lack of intentional activities. But they did not issue any interpretation of the provision itself. So here again, the legal uncertainty continues to exist, and even authorities don't really take the chance to give a firm interpretation and allow this legal uncertainty to be vanished. In Germany, at least, that's my area of expertise. That's the region where I work mostly, and we have not had any court decisions on the matter yet. So there has not been any official proceedings. So there again, there is no interpretation. So you can see that due to deviating FAQs and a lot of dynamic changes of the FAQs, there is legal uncertainty for economic actors in this area, which is very challenging, really. So it's important to always have a very close look to the wording of the regulation, to be in contact with authorities and try to sometimes even convince them that it might be not entirely convincing to follow the Commission. And this is one of the areas where I think a lot of clients do need some further advice. And this is just one example of the many challenges we have faced in the last year. Another one was on Russian vodka, where basically even the EU Commission's press release stated that Russia was then sanctioned. But if you had a look at the annex, which lists the goods as just shown before, vodka was only listed there and weeks later. So you could see even, there might be deviating FAQs, there might be press releases, which are not always reflecting the wording of the regulations. And this creates a lot of uncertainty for the clients and a lot of very interesting, highly interesting challenges in this very dynamic field of law. If you have any questions, we'd be happy to answer them. And thank you for your attention for this first introduction.
Thank you from us for this great introduction into the world of sanctions and into the sanctions lawmaking. With these basics equipped, we move on into further topics and have as a next topic the effects of sanctions on pending contractual obligations. So we're moving now into contract law, and for that again we have a high-profile speaker, Maria Elena Giorgelli, will speak to us. She's a partner of the law firm Buffa, Bortolotti and Mattis from Torino in Italy. She is specializing on international commercial contracts since over 20 years and is currently also the president of the International Sale of Goods Commission of the UIA. She is also a member of the Commission on Commercial Law and Practice of the ICC and also the chair of the ICC task force B2C online sale conditions, which has also published a new model online business to consumer general conditions of sale text. And she has also co-authored the book Contratti di Distribuzione, International Distribution Contracts at Wolters Kluwer. So we are very much in the right hands with Maria Elena, and we look forward to your presentation on the effects of sanctions on contractual obligations. The floor is yours, Maria Elena.
Thank you. Good afternoon, everybody. Today, I will address the issue of the impact of sanctions on Russia on pending contracts. First of all, I have to say that the experience of these months, despite the variety of the possible scenarios, from the simple difficulty in exporting and reorganizing transport, to the impossibility to export a sanctioned good, to the difficulty of figuring out whether the goods are restricted or not, all have a common denominator. That is the willingness of the parties to find and negotiate a solution, and this also from the Russian side. So, of course, in order to effectively negotiate a solution, one needs to know and understand the specific context, how the contract is regulated and which are the legal alternatives that are possible. And in doing so, starting from the possible scenarios from an EU seller perspective, first of all, the seller needs to carefully examine the contract and the critical aspects. Where are we, and what kind of contract are we dealing with? And the scenarios here can be very different depending on the products it's going to be exported. Are we talking of a plant machinery or a single sale? Are we talking of ongoing supplies? And also when we are selling a machinery, in which phase are we? Has the machine been manufactured already? Have we received a down payment or not? It is first of all necessary to ascertain what obligation have yet to be performed and what obligation the other party must perform. This also helps us to understand what we are risking. Have we already received the payment or not? And what to do? Well, this is an evaluation that has to be done on a case-by-case basis. Can we continue with performance? Does my product fall in the sanction package? I need to carry out a new diligence on the people involved and on the product. It may be easy to check if I have the CN code of the product, and I can check if this code is indicated in the annexes of the EU regulations and if these are prohibited or not. Is there a window, a time frame within which I can still deliver? And is this compatible with the deadlines indicated in my contract? I might have to anticipate the delivery. Here it's important to negotiate this with the buyer. Or I might fall in the cases in which I can request an authorization. And in this case, well, do I have the time? Do I have to negotiate an extension of time with the client? Sometimes I do not know the exact CN code of the product. This happened to a client of mine who was selling a production plant specially designed for the Russian buyer. And to identify the correct CN code and find out whether it was restricted the export or not, we had to carry out the verification. That took time. So what happened and how did we manage in practice? Well, by cooperating with the buyer. Well, first of all, we immediately informed the Russian buyer that it was not possible to deliver, although the deadline was imminent and there were penalties if we delayed. But we informed them we cannot deliver it until we find out if we can export or not. And that we must make sure we do not infringe the regulations. And in the meantime, our delivery is suspended with the consequent relief from any possible responsibility. Then, as soon as we get the feedback from the consultant that the plant was not restricted, of course, we renegotiated the delivery terms and the transport and managed to export the plant. So the advice, especially if there are deadlines and penalties attached to the deadlines, is to notify the Russian partner that verification are being carried out. What about if the goods are restricted? If the goods are restricted and fall within the package of sanction, it is not possible to continue performance. Can we claim a force majeure and suspend performance? Well, here the European regulations are quite clear, and they provide for an exemption of liability that has to be regarded as an overriding mandatory rule. It's a special case of force majeure. It applies even if in the contract the parties have not inserted a force majeure clause, and to my opinion it applies even if the force majeure clause inserted in the contract or the applicable law provide for more restricting conditions to invoke the force majeure, because it's an overriding mandatory rule. But apart from that, what are the consequences? The performance is suspended, but here in a business relationship, we have to deal with a lot of effects. For example, usually, unless ruled otherwise, each party bears its own costs. The principle is loss lies where it falls. But how we thought about storage costs, it depending from the product I am selling, and to keep the goods in the warehouse, it may have some costs. Can we negotiate with the other party a solution? This is what happened in these months as well. Furthermore,
Maria Elena, sorry to interrupt, very sorry. We just received the message that it would be great if you could speak a bit louder. For me, it's okay, but it seems that for others, it's maybe not loud enough, maybe a bit closer to the microphone. I'm very sorry.
Okay, I hope you can hear me, and I'll be happy to repeat what you missed, maybe at the end, so that I don't delay the intervention of the other speakers. In any case, a last issue that has to be considered, it is now likely that the sanction will last for a long time. So it must be examined whether we want to leave the performance suspended or rather think about possible termination of the agreement. And of course, is unspeakable that this will be dealt while negotiating with the counterparty. Otherwise, we'll have to see what the applicable law provides and which solutions we can have. Finally, just a few considerations have to be made from the perspective of the EU buyer. The sanction imposed change here the geography of supplies. This is inevitable. If there is a EU manufacturer of wood pavements, for example, and where has all his main suppliers in Russia, how shall he deal with its clients downstream? He cannot produce the needed quantities. Does he have to cancel orders? Will he be responsible for delays? Can he invoke force majeure? The scenarios here can be very different. Of course, the question here is other alternative suppliers, because it would be extremely difficult to invoke a force majeure if there are alternative suppliers. For example, if there are wood suppliers in Finland or in Latvia, even if this costs more, it would not go under a force majeure. The procurement risk usually lies upon the seller. So a force majeure may not be a valid solution. Hardship could be a similar situation. We need to increase price downstream, but then I would need a hardship clause or a price adjustment clause. If there is not one in the contract, it shall depend from the applicable law. And the solution is different from according to the jurisdiction we are in. For example, it would not be very easy in Italy, because in Italy, in case of hardship, the party affected can terminate the contract, but cannot impose a price, a rediscussed price, if the other party does not agree. In other legal systems, I know it's different, and they provide for the duty to the party to negotiate. Of course, negotiation in the end, and I want to finish as I started, that I think that the most strong tool to manage pending contract is negotiating a solution with contractual partners and all the parties involved. So thank you, and I hope you have heard all my speech, but I'll remain here till the end for questions.
Thank you. Thank you very much, Maria Elena. I heard you very well, and if others have problems with the sound, maybe it helps to put up the volume at your speakers as well. That was a very interesting and useful presentation on the contractual effects. We will now move to different topics away from contracts, now into the regulatory area, and we'll hear about the effects of sanctions on the movement of Russian citizens. Obviously, the movement of persons is a very delicate issue, and we have the perfect presenters for this topic. We have Ellen Freeman with us, who is the founding partner of Ellen Freeman Immigration Law Group. She has over 20 years of experience in all facets of employment-based immigration and is widely recognized for her experience in this area. She was a board member of the Board of Governors of the American Immigration Lawyers Associations from 2018 to 2021, and past chair of its global migration section. Together with Ellen, we will also hear, or after Ellen, we will also hear from Dirk Nuwitz. Dirk is a European Union corporate immigration lawyer since 25 years, also vast experience in that area for a long time, and member of the Brussels Bar. He is currently residing in Switzerland, and he's there heading the EMEA immigration practice of Ernst & Young. So the floor is yours, Ellen. And I might add that Ellen is currently in transit. Ellen, I take this point for you now. Ellen made it possible to speak here with now having a stopover at an airport to make this timing. So please accept our apologies in advance already for any background noise. I hope it will work. Ellen.
Thank you so much. Good afternoon, everyone. Thank you so much for covering the migration issue and the freedom of movement in connection with the Russian sanctions. So unlike contractual law, U.S. immigration is very black and white. You can or cannot do certain things, and it's impossible to negotiate with authorities most of the time. The sanctions are intended to inflict pain on Russian citizens, and as you know, in diplomatic relations are always issue of reciprocity. So growing up in the former Soviet Union, I'm very well familiar with Cold War, and it feels like we're back in Cold War with the closing of most of the consular missions between the United States and Russia. So most of the Russian consulates are closed and defunct in the United States, same as appearing in Russia. There is no diplomatic mission other than the hardly staffed embassy in Moscow, which can only deal with diplomatic visas. So Russian citizens cannot apply for any kind of visas except diplomatic in Russia. They, in fact, are declared now as stateless people, people that have no nationality. It's the same with Iran, and I will make more comparison with Iran, actually. So just like apply at consulates outside of their home country. But with Iran, there are specific consulates that are designated to process Iranian citizens' visas, such as Austria, for example, in Vienna, such as Armenia, such as UAE. The Russian citizens have been assigned to Warsaw, except that Warsaw has enacted restrictions on entry of any Russian citizen by air or sea. They can only enter by land, and even then, they're having a very, very difficult time securing a Schengen visa to enter Poland. So in fact, the immigration sanctions in the United States affect the most vulnerable Russians. They're affecting parents of US citizens, spouses of US citizens who otherwise would be welcome here and who will be coming here anyway. People are waiting for years to find an alternative consulate to try to process visas. It's very, very difficult. And in fact, a lot of the Russian citizens are now resorting to going to Mexico and trying to cross the border, just like hundreds of thousands of other unauthorized migrants who are trying to come to the United States, sometimes illegally, sometimes trying humanitarian parole and are allowed to come to the United States. So I have been involved in this type of case. And the sanctions that are supposed to affect the rich and the ones who are involved actually in the war in Ukraine are not as effective, able to go and apply for visas outside, far away from Russia, in places like Dubai, like Bangkok. Not even believe, but some of them are even going to Madagascar. So again, place in the world where you are located, but you have to show why are you located there. You have to demonstrate that you have some kind of reason that brings you there, more than just attending a fashion week in Paris or Milan. And that's what a lot of Russians are trying to use now. You have to be actually working, for example, in London or in another jurisdiction. So far, it has been really, really difficult for majority of Russian citizens, and it really affects Russian students, Russian scientists, the ones who we want to welcome into the United States. They're having the hardest time. A lot of their visa applications are also subject to what's called administrative processing, meaning that the government needs an additional time to review their visa applications, and there is absolutely no time period as to how soon the Department of State will get back to them. It could be 1 month or 10 and 12 months. A lot of those people give up on their hope to come here. Some go to the former Soviet republics, such as Armenia, Georgia, Kazakhstan, used to be Uzbekistan, where they're trying to apply for visas. But there is such a huge influx, as you know, of especially Russian men who are fleeing Russia because of the mandatory conscription and going to live in those countries. We hear numbers that 300,000 people left Russia right after the mandatory conscription was announced. So the consulates there are to really assist most of the people. They're too understaffed. The Department of State is very understaffed these days. They can only process visas for relatives of US citizens. And I'm sure that Dirk has similar report about the difficulties in securing Schengen visa, and I will pass the floor to him. I'm happy to answer any of your questions. Please email me through the chat or to efreeman at Freeman Immigration Law Group or through the UAE, and I'll be happy to answer your specific questions. Thank you so much for the opportunity.
Thank you, Ellen. I hope you can hear me, because I'm not sure. It seems immigration lawyers are traveling all the time, because I'm currently, that's why I'm not going to put on the video, because I'm not properly dressed to be to be on the video, because I'm currently on vacation in Brazil with my family for my 50th birthday. But I didn't want to miss this call. So I wanted to share the input from an immigration point of view regarding the sanctions towards Russian in the Schengen area. So as you know, Russian nationals, unlike Ukrainian nationals, need a Schengen visa to enter the Schengen area. when on the 24th of February, when the war started between Russia, or when Russia invaded Ukraine, there were around 12 million Russians holding a valid Schengen visa. And you have to know that between 2010 and 2019, 35% of the total volume of Schengen visas that has been issued were for Russian nationals. So Russia has been, during 10 years, the number one receiver, or Russian nationals have been the number one receiver of Schengen visa. China, for instance, is second, but that's only 14% of Schengen visas in that period. So when the situation on the 24th of February last year started, some of the EU countries asked for a travel ban for all Russians into the European Union and into Schengen. Now, the European Union was not so much in favor of that. A group of countries like Slovakia, Czech Republic, the Baltics, Denmark, Finland, they have asked that 2 times during an EU Commission meeting, but 2 times it has been refused. When in September, the EU has decided is that the traveling or obtaining visas for Russian nationals is becoming more complicated. Since 2007, there is was a visa facilitation agreement in place between Russia and the Schengen area. So Russian nationals could easily obtain, and for a cheap price, obtain a Schengen visa. Now that has been suspended since September of last year. That means that for Russian nationals to obtain a visa for the Schengen area, it will take them more time. So there's no ban on issuing Schengen visas for Russians. So, but it will be it's more time consuming. It's heavily scrutinized. Instead of 15 days before, it takes 45 days. The fee has increased from 35 euro to 80 euro. And the procedure that's followed is in fact the ordinary Schengen visa process. What also has been decided by the EU is that non-essential travel has to be deprioritized. So no short stay visas are in principle issued, and also no transit is in principle allowed. Also tourism, the EU has clearly said that tourism is not a right. So also tourism is not considered essential travel. I also apologize if there's any background noise, by the way. The non-essential travel, tourism is not considered essential travel. So these kind of visas either are denied or will also take a lot of time before they are approved. But in principle, they are denied. Another thing that I wanted to share with you is that some countries in the European Union anyway have implied a travel ban, like for instance, or a visa ban, like for instance, the Baltics, also Finland, Denmark, because they base themselves on Article 25 of the Schengen Agreement, which says that in case of a danger of the public security, a country can decide to refuse certain nationals or certain visas. Another thing I wanted to share with you is that in order to obtain a visa, very often, also for work permits, for instance, because well, I'm an immigration lawyer, so also we deal with work permits. For work permits, sometimes for Russian nationals, sometimes documents are needed out of Russia. Well, this is becoming very burdensome to obtain legalized or apostilled document out of Russia, because courier services, like the big multinationals, usually American courier or German courier services, are not operating anymore in Russia. Also because there's problems with the flights. As you know, there's no flights allowed anymore from Russia going into the Schengen area. So you have to try to work with either post, but that's not also reliable, or with local Russian couriers, which is also not so easy. We have had a situation with a client where everything needed to be sent via Kazakhstan, because there's a courier service between Kazakhstan and Russia. It's called Pony Express. It's not something Buffalo Bill like, but it's a Russian company. So it's very burdensome and very difficult. Another thing also is that the golden visas have been, the golden visa process have been denied for Russians. So before you had a lot of Russians applying for golden visas into Cyprus, into Portugal, Malta, or even Switzerland to a certain extent. That has been completely abolished. So that's not allowed anymore. And then, of course, as was mentioned already before in this call, if a person is connected or is listed on the list of prohibited persons of the EU, these people absolutely have no right to enter the European Union or the Schengen area. Since the 24th of February, Frontex, the European border authorities, they have mentioned that 1.5 million Russians have already entered the European Union with their valid visa. Now, the thing is, if these visas expire, also to renew the visas, they need to show that they are essentially needed in the European Union. Otherwise, they will not get the visa. And the last thing I wanted to mention is that people who are holding a Russian passport out of a region that is considered as the occupied territories, so Ukraine, but also Abkhazia in Georgia, South Ossetia, Crimea, Sebastopol, Donetsk, Luhansk, Kherson, and another one, which the name I forgot, in Ukraine. If they have the Russian passport for these people has been issued in one of these regions, the EU will not recognize the passport, so they will refuse. Finally, also something about Ireland, because as you know, Ireland is an EU member state, but is not part of the Schengen area. Ireland has removed Russia from its short stay visa scheme, which means, which permitted nationals of third countries who entered the UK on foot of certain UK short stay visas to travel to Ireland without being required to obtain a specific Irish visa. That has been abolished. So now they need a specific Irish visa. So I think that those were the main elements that I wanted to share with you regarding the Schengen area and Russian nationals. So most important to remember is that the visa facilitation agreement has been abolished, and that non-essential travel is deprioritized. So I think that's it from my side.
Thank you very much, Dirk and Ellen, for your very interesting presentations. We will move now from the regulatory immigration issues to an entirely different topic, a very interesting topic that also makes a lot of noise in the news. The effects of sanctions on the use of recreational vessels. And for this interesting topic, we have Alberto Passino, a partner from the law firm Zunarelli in Trieste in Italy, speaking to us. Again, a very suitable match for this presentation. He is president of the Transport Law Commission of the UIA. And for example, he has been also a member of the committee that drafted the 2005 Italian recreational boating code. So a lot of transport and shipping experience here for us, with interesting information on the freezing of vessels. I've heard from colleagues that some spend a vast amount of their time on this topic since last February. So truly topical. Thank you, Alberto.
Thank you very much, Veit, for your kind introduction. There are currently about 20,000 yachts in France, Spain, Italy, and Germany, allegedly belonging to listed individuals. Today, I'm going to try to outline the main legal issues that arise in relation to their freezing, mentioning some precedents, bearing in mind that while some concern pleasure yachts, other concern cargo vessels. However, I believe that the latter two are useful to get a more complete picture of the approach that the judges have towards the issue of the application of sanctions to vessels, of which pleasure yachts are a subcategory. The issue of the enforcement of Regulation 269 of 2014 is particularly important with regard to vessels, since they are assets which, by their very nature, can easily be removed from the control of the national competent authorities. The freezing measures contained in the regulation are directly applicable law pursuant to Article 288 of the Treaty on the Functioning of the EU. Given the principle of loyal cooperation, member states are obliged to effectively enforce the freezing requirement and the prohibition of making available funds and economic resources, which they do by enacting criminal provisions and prosecuting them. Further enforcement acts are not provided for in the regulation, so that any further measures are left to the domestic legislation of the member state. Germany, for instance, has complied with the obligation of effective enforcement by introducing new criminal provisions which punish violation of EU sanctions. Seizures or confiscations are only permissible under German law if there is a risk of a sanctioned violation. For example, if there is a risk that frozen assets might be disposed of because these assets are being offered for sale or rent, for instance. In other countries, enforcement has sometimes been implemented through measures that have the nature or effects of a seizure. In Italy, for example, the NCA is entitled to adopt any act necessary for the correct and timely implementation of the freezing measures provided for by the European Union pursuant to current legislation. Powers which include the assignment to the Italian Agency of State Property of the custody, administration, and management of the frozen asset, and which ultimately result in a seizure. France has taken a hybrid position. Customs officials have seized vessels in some cases, but since in some instances, such as that of the Paola Ariake case, the relevant measure was annulled due to procedural reasons, and the administration was ordered to compensate the damages, it seems that in other cases, they have not adopted any seizure measure. Indeed, when the vessel is a pleasure yacht, French customs basically consider that the person that owns the vessel is the custodian and guardian, and they do not seize the yacht. A recurring issue in maritime law concerns the question of piercing the corporate veil, since very often the owning companies of ships are structured in such a manner as to avoid liabilities already accrued, and it is necessary to determine whether there is a genuine link between corporate structure or the veil ought to be pierced in order to treat the liabilities of the relevant company as the liability of its shareholders or directors. The issue as regards the general theme of maritime law is treated differently in the various jurisdictions. Naturally, it is also relevant with regard to sanctions, since registered owners of frozen yachts practically never coincide with listed persons. The relevant provision is Article 2, Paragraph 1 of the regulation, pursuant to which all funds and economic resources belonging to, owned, held, or controlled by any natural person or natural or legal persons, entities, or bodies associated with them as listed in Annex 1 shall be frozen. It is worth noting that the Italian version of such rules add to the expression owned, held, or controlled the words directly or indirectly, increasing the possibility of inconsistencies in its interpretation by the member states. The only precedent known to me in which the corporate veil withstood judicial scrutiny is the one resolved by the Court of Lorient in the case of the Paola Ariake, a cargo vessel, since in that case, the court annulled the domestic implementing measure because it found that the vessel did not belong to the listed person. The Spanish courts have acted differently when adjudicating the dispute related to the freezing of the yacht Meridian A. In April, a Madrid court dismissed the objection of the registered owner that Spanish authorities could not prove who owned the yacht and could therefore not freeze her. The Italian courts have decided similarly. In the Lady M case, an Italian court held that, and I'm quoting, for the freezing measure to apply, it is sufficient that the resource, although formally belonging to an unlisted entity, is in any case attributable to the listed person through possession, holding, or control, which can also be carried out directly or indirectly by any natural person of any of the natural or legal persons connected to the person whose name is in the list. Apparently, up to now, the defenses aimed at leveraging the distinction between registered owner and listed persons have not been listened to by the courts. Now you might ask yourself, are vessel and pleasure yachts economic resources? Article 1, letter D of the regulation establishes that economic resource means an asset of any kind, whether tangible or movable, which without being a fund can be used to obtain funds. The EU Council is of the opinion that assets which are only suitable for personal use or consumption and therefore cannot be used by a designated person to obtain funds, goods, or services do not fall within the definition of economic resources. Therefore, they are not covered by the regulation and no authorization is required, according to the Council, to make them available to a designated person. Back and forth, this interpretation in case law is rather scarce. While the Lazio Administrative Court in the Lady M case, with implicit motivation, does not doubt a yacht is an economic source, the Court of Appeal of Paris in the Petit Ours case, despite the parties raised the issue, does not go into the merits, while the Tribunal of Rennes in the Vasily Latishev case and the Tribunal of Lorient in the Paul Ariake case are of little help since they concern cargo vessels. So if it is true that there are few doubts that a commercial vessel is an economic resource, when dealing with pleasure yachts, the matter is definitely less univocal. It seems to me that there are two fundamental issues. The first is formal in nature. Each time it is necessary to ascertain whether or not the yacht is a commercial vessel. And in this regard, the first aspect to be considered is whether or not such yacht is registered as a commercial yacht. If she is, it would be very hard to argue that she is not an economic resource. If on the contrary, she is registered as a pleasure yacht, it would be highly questionable to consider her a commercial vessel, since according to various legislations, the declaration of a yacht as a pleasure yacht clearly implies that the yacht is not a commercial yacht or cargo vessel and may not be used for commercial purposes of gain, and cannot therefore constitute a source of income, since she is not even a vessel that complies with the provisions prescribed by the class and flag regulation for commercial vessels. A parallel issue is that of verifying how the yacht under freeze is conceived functionally. In fact, if it were established that she was an asset designed and built for the exclusive enjoyment of the person who commissioned her construction, she could reasonably be excluded from the objective scope of application of the rule. Let us think of the case in which a yacht functions for more or less extended periods throughout the year as the owner personal resident and has therefore been built to exclusively satisfy his particular function or aesthetic needs. In brief, it is necessary to establish each time whether the yacht under freeze has good marketability and can actually serve as a substitute currency. If for some yacht, this is more than likely true, it is equally reasonable to argue that other yachts under freeze have no marketability, also due to the identity of their current alleged owners. Then there is the issue of personal use. According to the EU Council, personal use of frozen economic resources, for example, living in one's own house or driving one's own car by a designated person, is not prohibited by the regulation and does not require an authorization. If it is possible to drive one's own car, which is by its nature liable to move away from the jurisdiction in which the regulation is applicable, logic would have it that the same could be done with any other registered movable property. The observation of how this obvious postulate is currently applied is rather perplexing. Well, the matter is mostly theoretical. Listed individuals are also hit by entry and transit bans, which makes the issue of their personal use of the yachts they allegedly own a purely theoretical one in the majority of cases. And also, if a listed individual argues that he is not the owner of a certain asset, as listed individuals normally do in almost all cases of yacht freezing, would it be consistent with this line of defense to request to enjoy the right of personal use should it be denied by the NCAs? Anyway, in France, sanctioned individuals are allowed to access their yachts and use them within French territorial water, or if they are subject to administrative seizure, at the mooring place where they are ordered to remain. In Italy, the personal use of frozen vessels has instead been denied so far. The big question when we deal with frozen yacht is who pays the bill. In France and Spain, since the person that owns the vessel is the custodian and guardian, its running costs remain the owner's responsibility. In Italy, the situation is reversed. The expenses are borne by the state, which is entitled to recover them once the freeze is lifted. However, if the assets cannot be kept without danger of deterioration or without significant expenditure, the state is entitled to sell the asset at any time. To date, the state has not yet used this option, which seems to me a very wise choice, given that such rule conflicts with the regulation, which has no punitive nor confiscatory nature, and which therefore cannot be interpreted or implemented in ways that involve the sale of the asset. I have reached the conclusions. Apparently, there isn't a univocal application of freezing measure within the EU, which leads to a situation of serious disparity, the most relevant of which pertain to the personal use and maintenance decisions and costs. The lack of interpretative uniformity leads to paradoxical situations, such as the French one, in which the adoption of administrative seizures is held back by the fear of incurring serious financial liability, or the Italian one, in which the implementing rules in force have been adopted to contrast mafia and are clearly not fit to effectively implement the freezing measures. These inconsistencies can easily result in the violation of principles protected by the European Convention of Human Rights. First of all, the right of property. This should induce, to my view, the EU to at least amend their FAQs so that those discrepancies are avoided in future, and to avoid that the distorted application of EU rules is perceived as a form of retaliation on selected Russian individuals. And for now, that's all from my side, and let's see what the other speakers have to tell on this topic. Thank you, Veit.
Thank you, Alberto. Yes, we're moving on to a different area, to the food industry and the pharmaceutical and medical devices sector. This is a sector that is not directly covered by sanctions, but obviously greatly affected still by sanctions. So we will hear on this from two speakers, from Magdalena Zielinska-Kucz. She is a Polish lawyer with the law firm WKB in Warsaw. She advises on all aspects of food law and is also a member of the board of the Agri-Food Law Commission of the UIA. After her, we will hear from Eliana Silva de Moraes. Eliana is a partner of the law firm Silva de Moraes in Sao Paulo in Brazil and in Paris. And she specializes also on food law, but in addition also on drug law with a particular focus on regulatory affairs for medical devices, pharmaceutical, cosmetic, and food products. And she will cover the pharmaceutical and medical devices aspects of the next part. She is president of the Health Commission of the International Association of Lawyers of the UIA. She's a professor in health law at the Institut Supérieur de Droit in Paris. And she is also the president of the Brazilian Regulatory Affairs Society, a member of the editorial advisory board of the Journal of Medical Devices Regulation, and the council of the Brazilian Chamber of Commerce in France. So another great expert we have here to present to us. We're looking forward to this, and the floor is yours, Magdalena.
Thank you, Veit, for your kind introduction. I hope the presentation will work. Yes. I would like to start my presentation with this photo showing the field in Ukraine, full of numerous traces of shelling. And as we all know, not only fields, but also the strategic infrastructure, including the grain silos, the places where the agri-food products are stored, were also targeted by Russian missiles. And it shows clearly that, unfortunately, food is a weapon in war. And as we know, this war in Ukraine has an important impact on the food security in the world. What was underlined by all the international organizations that watch this impact on the food sector. And we know that the war prevented farmers from working in their fields. We know that the future harvests in Ukraine are uncertain. The exports in Ukraine were blocked or partially suspended. And as the military action goes further, and there are long-term consequences for Ukraine to have the ability to export their products, the agri-food products, not only inside their territory, but also outside their borders, especially if the port facilities and railroads are destroyed. And why this is so relevant, why this is so important to talk about it. If you take into account that Russia and Ukraine are considered the global breadbaskets, that those countries are the key global suppliers of cereals and sunflower oil, then you understand what and how huge the impact on the food security in the world this war has. It is said that every third portion of French fries in the EU is fried in Ukrainian oil. It is the data showed that only in 2021, wheat exports by both Russia and Ukraine together, they accounted to around 25% of global exports. And when we are talking about sunflower oil exports, those both countries the combined number goes to 72% of global exports. We also know that Russia is a leading producer and exporter of fertilizers. Not only Russia, also Ukraine. So and as a result of this war, the global food prices, although they were already high before the war started, not only due to the pandemic of COVID, but also to other factors. But after the war started, the prices reached the levels, the high top levels of any time of a certain food goods. So the impact, as you see, of the war on the food sector is high. You can see it by comparing the numbers. This graphic shows the share of the main Ukrainian commodities in the country's total imports. There are many importing countries that are totally dependent on the agri-food products that are imported from Ukraine or Russia. Just to show the Lebanon, it's 80% of wheat they obtain from Ukraine. Also, other Middle East and North African countries import more than 50% of their cereal needs from those two, and mostly from Ukraine, but also from Russia. What shows that if the production is in somehow stopped or is in difficulty, if the transport of those products is not so easy anymore, and taking into account also the issue of fertilizers that we will come to this afterwards, the scenario in the world of food and agri-food products is really not, let's say, positive. The situation is quite emerging and difficult. I will try to pass to the next slide. And as Veit and also Mareike and Christoph said on the beginning, generally the food products and agri-food products are not targeted by EU sanctions, right? So it means that generally European companies can purchase and buy and export food products to Russia and from Russia and to Ukraine and from Ukraine. But of course, it's always there are some problems in interpreting whether which in fact products are covered by sanctions and which are not. This Mareike on the very beginning explained this problem with the frequently asked questions and there is not always the information that is included in the regulations on sanctions. Those data do not always is the same with what is said in this frequently asked question as with the vodka, as the similar situation was with the fertilizers. That, for example, there was an information that the commerce with fertilizers is free from sanctions, that we can freely buy it, but it is not entirely true because the certain fertilizers are included on the European sanction list. But what is important is that generally the food products are excluded from sanctions. And it is also important to say that European states can grant access to EU ports of vessels flying Russian flag, and also to the road carriers if the transport regards the agricultural products, including fertilizers and wheat, because those products are generally excluded from sanctions. Recently, in December, the 9th package of sanctions against Russia was adopted, and again, also in this act, the European Union, European Commission underlined how important the implications of war are for the global commodities, especially for agri-food products. And it is not everyone know that during this negotiation of this package, there was a huge political debate around the possibility to unfreeze the assets of certain individuals that were listed on a sanction list in the European Union, if they are connected with the production of food and fertilizers. And Poland was against this, let's say, this approach and this derogation, but finally it was anyway introduced, and now member state can unfreeze assets of such individuals. And this is very, let's say, also let's say that there was a huge political debate around it, whether it was whether it is a good tool or not. But finally, it was approved, and now each member state can do it. And of course, they should do it in cooperation with Commission to ensure uniform implementation of sanctions within the EU. And talking about the impact of the war on and sanctions on the agri-food sector, we cannot forget that there was a huge movement of from the business, not only from the food sector, but this sector was very much involved in leaving Russia, notwithstanding the fact that their products were not covered by sanctions. So a lot of food producers and sellers left Russia. McDonald's is one of the examples that was also there was a huge debate around it. After 30 years, they left Russia. And as I am a Polish lawyer, I would like to show you also the perspective of how the Polish authorities reacted on the very beginning to the war. And this is the announcement, the public release that you can find in the internet, of the president of the Office of the Competition and Consumer Protection in Poland. This is a very powerful and very important authority in Poland. And when the war started, they openly called the consumers and encouraged the consumer to boycott the products from Russia. And this is the announcement that is still on their website. They were also indicating and underlining that a lot of shops, a lot of retailers, food retailers, decided to withdraw the products that are provening from Russia from their shelves, including Aldi or Carrefour. And the president of this Office of Competition and Consumer Protection was even indicating to the consumers what are exactly the codes of the products that provene from Russia, so the consumer could better understand that those are the products from this country. There was even a bill in Poland. It did not, it was not passed at the end of the day, but there was a bill, the proposal to even oblige the shops to exhibit the Russian flag on clearly on the food products, and not only food, so that the consumer was better well informed of the provenience of the product. And I would like to show you also one example of sanctions that were implemented on the Polish market. As our colleagues on the very beginning said, we do not have only to deal with the European sanctions, but we also have the national sanctions. Each country can implement their own sanctions, and also Poland issued a list of sanctioned companies and individuals. And although the food products are generally exempted both from the EU and also from the Polish sanction list, there was one company that was included on the list, and this was Magna Foods. And there was a big debate and big rumors around it in our press, because the company retained that their inclusion on the list was wrong, that there were no basis to include them on this list. The ministry said that they were recognized to be indirectly controlled by one of the oligarchs, Mikhail Friedman, connected with one Russian private bank. And the important thing about this case is that the company employed about 200 people, and half of them were Ukrainians. So the company was, from one day to another, was in the situation where their assets were frozen. That we are talking about the food, so the material that have the shelf life of around 2 weeks. So if we stop such a company from doing business, from commerce, then the product simply is wasted. And what happened in this case is that they applied twice to be cancelled from the list, and on the second time they were successful, and after 4 months the company was cancelled from the list. And it was because of the change in the ownership of the company, and the company was, let's say, saved by the own employees that bought the company. So this is an example of how, let's say, this war of how huge the impact on the food sector is in nowadays. And this is all from my side. I will pass the floor to Eliana. I can only add that I saw, although these food products are not sanctioned, I saw many examples, especially on the very beginning when the war started here in Poland, that our authorities didn't want to make the Polish businesses to pass the agri-food products to Russia. And they were doing a lot not to make some, for example, export permits or some authorizations, some laboratory tests. They made everything to make it more difficult for the businesses to make business with Russia. Thank you.
Okay, thank you so much for this opportunity to talk about this important subject. And following the information that Magdalena just shared with us, I am going to focus on medical device and pharmaceutical, which are really close to the food aspects of the presentation. Before I start talking about this important subject, I would like to remember that most of concepts and understanding in international health law came from the experience gathered in the Second War. So we have a lot of treaties and a lot of understandings that we produced after the consequence of the Second War. So this subject is very important for us to cover here today. And yes, although the economic sanctions imposed by mentioned country, the West, against Russia do not target pharmaceutical industry or medical supply chain, as we could see, the sector is facing several challenges, in fact. As we could see, the international humanitarian treaty says that industries in this sector have a responsibility to continue supplying essential medicines and medical products for the region, for Russia Ukraine. So what companies must do according with the treaty that we have signed, as I said, as a consequence of the Second War. And this is very challenging, actually, because putting in practice the humanitarian treaty purpose is not easy at all. If we think about Russia situation inside, what is happening with their patients? So we can see this, how challenging to navigate the geopolitical crisis, but let's take firstly the patients that are inside of Russia. So as we know, Russia has a lack of medicine manufacturing capacity and dependence on the international supply chain, especially when we think about active pharmaceutical ingredient, which we call API. So it's huge, the difficult to have API in the country. About 85% of its consumption of pharmaceutical company inside Russia comes from abroad. And as we could see from the other presentation, we have several difficulties to face regarding have a presence in the country and produce. And so their capacity to produce medicines product is limited to that. And we are not talking here about the Russian local manufacturing, but especially focus about multinational pharmaceutical on the Russia's market. So it's very challenging to them to have their presence in there, keep their presence in there, and provide products in the country for patients. And the same situation we find for the local medtech industry that relies on the international market as well. Assembly products, not all medical device products are assembly wholly completely in the country. So we needed to think about to bring their products in the country, and the difficulty with transportation payment. So Russia depends on the international market for pharmaceutical and the medical device supplies to put it as available for the patients. So the patients are in a precarious position. The companies that are producing them cannot assist regularly as they were doing. So supply chains have been disrupted by the imposition of no-fly zones, the removal of Russian banks from SWIFT international payment systems make it very difficult for companies to be paid for essential goods. And we need to think not only in product, the final product, but the whole supply chain that provides raw materials, packagings, all things that are involved in this industry. And so several risks of taking the hit financially we have now. And all major pharmaceutical companies have decided to stop new investments in Russia. And our concern, once again, is regarding patient situation. We have the disruption of the recruitment, for instance, for new patients by foreign life science companies into ongoing clinical trials. There were about more than 1,000 clinical trials active in Russia, involving more than 10,000 sites. And we are talking about sensitive products like oncological, diabetes products. It's very, very complicated at this moment for companies provide an answer positively with the humanitarian law. And 90% of the reduction of clinical trials in Russia are expected. And we are not only focused in Russia, but the region that Russia is leader providing products in this sector. And we have lost approximately 8,000 high-end jobs created by the IBPCT industry. So it's once again, it's not only provide, manufacture, but all situations linked with this industry to provide them. So more than 30,000 patients annually will lose access to cutting-edge experimental therapies. And implementation of a challenge of logistics in the war region, how to provide those products. We are once again talking about humanitarian treaties that focus in health, life. We are not talking about any political aspect of this situation, but health only. And this is very challenging for all of us that work with the regulatory affairs for pharmaceutical medical device, thinking how we could provide these products for patients that are needed to survive. And we have a high cost to patients into delivering the life-saving medicine and medtech product as well. Chronic goods shortage, high turnover rates. You can imagine how difficult to keep professionals in there. I'm not focusing in the situation that so that there may be civil population that are being called to serve in this war. So significant delays at the port, customs difficult for transportation of this product. But the problem is not only there. Once again, we are talking about this is very challenging, talking about the impact. And then when we see the global impact, it not only stay for the situation in the region, but for the whole global. When we talk about pharmaceutical and the medical device, we are in a global world providing this kind of products. So supply chain disruption, the life science industry, and it's touching not only the region, as I said. If we take my region where I come from, Brazil, and the whole Latin America situation, Russia is the world's largest exporter of nitrogen, phosphorus, and potassium. And the nitrogen is used in the respiratory equipment and sample freezing process, such as organ for transplantation, bone marrow, blood, and other types of biological material. So we are missing now raw material in the region. Brazil is suffering this. The industries are now saying they are having difficulties to find the raw material to produce their products. Phosphorus and potassium are very important raw material for pharmaceutical industry as a whole. And we also had we cannot say that we finished a crisis, a sanitary crisis regarding COVID, and now we have this challenge that was again to face and to realize how company will solve the problems in the region. So the conflict in Eastern Europe could compromise the whole supply of key elements for the medical device production of semiconductors and lasers such as palladium and neon gas. Such shortage of raw materials in pharmaceutical industry is very difficult regarding logistics, supply chain, high black and prices, and it's for sure we will have to face this situation. I know that we are running after the time. I will conclude here, just say that in other words, it's harder to answer how pharmaceutical and medical device will ensure patient safety and reorganize production in the middle of this terrible conflict between Russia and Ukraine. And for sure, huge impacts are touched this sector, and we need to help with our legal intelligence to find a solution for this important sector for the whole society. Thank you again for the opportunity to cover very briefly this important subject.
Thank you very much, Eliana, and thank you very much, Magdalena. We are moving on to a different topic, to the impact of sanctions on the insurance market. We are running a bit behind, but I can very much recommend that you please stay on. We have two more presentations, this one and then one last one. and maybe are still able to cover one or the other question afterwards. So the effects on the insurance market is going to be presented to us by Frédéric Banet-Philippe. She's founding partner with FB Conseil law firm in Paris and specialized in insurance law and compliance. Frédéric is the president of the UIA Insurance Law Commission. Previously, she was head of claims, legal and compliance in leading insurance companies and brokers in France. And she is also a reserve officer of the French Navy. Obviously, somebody again who will grant us a lot of insight. Frédéric, the floor is yours. I can see your slides, but I cannot hear you.
Can you hear me?
Now, perfect. Thank you
Okay,
very much.
perfect. Yes, last week I just met the chief economist of the Allianz Group, who told me we are in a war economy. Because of the COVID-19, the Ukrainian war, the climate change, the conflicts of generations, we are in a war economy. And of course, the insurance players anticipate as many risks as possible, including an international conflict. So what is the situation today? The international sanctions are affecting the insurance coverages. First, because most of the business activities in Russia or contractual relationship with some Russian individuals, financial institutions, and public and private entities are not covered anymore, except by local insurers in Russia on local standalone policies not reinsured by international players and with limited financial capacities. Many Occidental insurance players close their local offices, which means a disruption of the insurance services. The financial transactions are blocked. The Russian banks are barred from using the SWIFT system. The financial transaction with the Russian central bank have been blocked, which means again that even when the business activities are authorized, food or medicine, for example, the financial transactions are suspended by the banks. So the insurers cannot collect the premiums and just cannot pay the claims. The Ukrainian war is having an impact also on the insurance business. In certain lines of business, not all of them are affected. For instance, the casualty policies, political risks, financial lines, including the directors and officers insurance or fraud, the PI insurance, are not so much impacted at this time, but we have much more impact on, for instance, transportation. We know that in aviation, airline insurance, we remind the Russians' confiscation of more than 400 aircrafts last spring, with an estimated total value of more than $12 billion. And this will have an impact on the insurance prices. The insurance premiums have already increased by approximately 50% in 3 years. As regard the property insurance, we have Ukrainian exposures, not Russian one, but Ukrainian one, and insurers receive more and more claims related to infrastructures damaged or destroyed. And today, the assessment of the potential indemnities for losses made by the reinsurers is between $9 and $11 billion at this stage, having in mind that Ukraine was already very under-limited due to its country risks, but today the risk of financial capacity versus the volume of claims is increased, of course, having also in mind that in the property insurance policies, you have an exclusion, a war risk exclusion clause, which means that all the losses and expenses arising from wartime activities might be disallowed. As regard the credit insurance policies, which are underwritten by private companies to guarantee their investments and exports to Russia and Belarus, because we are talking about Russia, but we do not have to forget Belarus. These policies are beginning to be activated due to the freezing of transactions with Russian banks and the payments defaults. With the exclusion of Russian banks from the payment system SWIFT, many transactions are blocked. So the credit insurers have now changed their position drastically, reducing or even canceling the coverage. So they do not offer any more guarantees for the new financial flows to the regions. And this could lead to disputes over how insurance contracts are interpreted or implemented, depending on how, of course, they are drafting. A few words on the war risk insurance policies. Generally speaking, in the insurance contract, you have an exclusion of war risk because we have dedicated insurance policies protecting against losses caused by events such as invasions, riots, strikes, revolutions, military coups, terrorism, and various attacks, including nuclear attacks. Insurers today are considering a worst-case scenario of a nuclear conflict, much more local one, but potential one. And this might have a direct impact on, of course, the activity, the business activity, and on the insurance coverages. I'll give you one example. In aviation insurance, you have the nuclear risk is systematically excluded by a clause named AVN 52, and this clause provides for the immediate suspension of all aviation insurance coverage in the event of a nuclear detonation, which means that all the aircrafts would be grounded from one day to the next. And today, insurers and reinsurers are working on a solution to avoid blocking the worldwide traffic. So this is a real challenge for the entire market, of course. We face the potential of the exclusion of Ukraine for the renewals of the war risk insurance policies. Of course, we have a concern about the financial capacities because this insurance program just have 200 million euro roughly of capacity, but and does not concern all the business activities, but the major ones, oil and gas, real estate, hotels, these kind of things, but not all the business activities. We have to also have in mind that Russia is not in a risk of war at this stage. Ukraine, yes, but not Russia. Russia is in a situation of aggravation of risks and confiscation of foreign assets and goods, plus an increased risks of strikes, riots, and popular violence. And again, a few words as regard the war risk about the cyber. We have specific cyber insurance policies, and we know that the brokers and the policyholders are very concerned about the proliferation of cyber exclusions and limitation in the contracts in 2022. The Lloyd's has just published a model clause excluding the risk of war from the cyber policies, when the demand for coverage increased exponentially in 2022, and many insurers and reinsurers withdraw from these markets, causing a financial capacity crisis for the cyber risks. In October 2022, in France, the Conseil d'État, the French Administrative Supreme Court, validates the insurability of the cyber ransom, provided that 24 hours after the cyber attack and prior any payments, an alert be sent to the police, because paying a ransom is not illegal in France. A few words about compliance. As it has been said previously, we have a lot of legal uncertainty for economic actors, including the insurance players, about the sanctions compliance and enforcements. Today, of course, the reinsurers, insurers, and all the markets and their clients must analyze their exposure with regard to their activities in Russia prior any decision or of investments. In France, we have a very strict interpretation of the EU sanction regime because if an insurance or reinsurance players like their clients have in France, they have an obligation in results with respect to the enforcement of the sanctions and the asset freeze regimes. So if a company does not comply with the EU sanctions regime, it exposes itself, its directors and officers and employees to civil and criminal penalties up to 5 years of jail and a fine equivalent to twice the amount of offense. And the same, of course, for the foreign subsidiary of a foreign group, if it breaches the sanctions regimes, of course, the local DNOs and the parent companies once incurred the liability. The problem is that the sanction clause in the insurance contracts are not harmonized, even though sanction clause has been drafted by the French Insurers Federation, France Assurances. I have an interesting case law of the Court of Appeal of Paris dated of June 2022. This is a ruling by the Paris Court of Appeals that rejected the insurance company AIG's Europe refusal to cover the defense costs of the Groupe Lafarge executives in the context of the criminal proceedings opened in Paris and Brussels in connection with the company's activities in Syria between 2013 and 2014. And the sanctions clause at issue in the Lafarge case was introduced by an endorsement in 2015 to exclude from coverage conduct in violation of international sanctions. And AIG is now condemned to settle the defense costs of the Lafarge DNO on the ground that the sanction exclusion clause is legally not valid and the list of the sanctioned countries is not attached to the insurance policies. So the lessons to be learned from this decision of June 2022 are all the more valuable in light of the sanctions imposed on Russia after the invasion of Ukraine. We have a few exemptions to the sanctions regime. For instance, there is no need to require permission from the French Treasury Administration in case of health expenses, car and home insurance premiums, lawyers' fees, and also private NGOs providing humanitarian aid may be exempted of freezing of assets subject to the GGT validation. Again, one French case law from the French Supreme Court dating of July 2021, this related to Iran. The French Supreme Court overturns an appeal decision which criticized the bank for having notified the client company of its decision to close its accounts without prior notice, on the grounds that this account had been used to make a payment by an intermediary who was circumventing the international embargo rules against Iran. And this is the first time that the High Court has ruled on the banker's right to close a deposit account in this context. So to conclude my presentation, the insurance market tries to adapt itself to the constraints consequent to the Ukrainian conflicts. Things are moving very fast. And in 2023, we expect insurers to pass on higher reinsurance prices and tighter conditions and more exclusions in the contracts. So I can just recommend you to advise your clients to review with scrutiny their insurance contracts, the exclusions and scope of coverages, and to analyze whether these contracts are or not adapted to their risks. And as lawyers, I recommend that you analyze the insurance aspect of your pending case law in general, and in particular in the context of the Ukrainian conflict. And I'm at your disposal to provide you and your clients some support in this respect. Thank you very much.
Thank you very much, Frederic, for this insight into the insurance sector. We are coming now to the final presentation of our webinar. After having heard now a lot about sanctions themselves, about several areas of law, of contracts, of certain assets, of certain sectors, how they are affected, we are moving now on to the world of disputes and dispute resolution. We decided to not cover litigation, considering in particular also that litigation, court litigation, will usually have in each country likely very different approaches to certain issues, but have decided to end today with arbitration and the effects of sanctions on arbitral proceedings. This topic will be presented to us by Elena Gillis-Cintrano. Elena is an associate at the Madrid office of Uria Menendez. She's specializing in arbitration and litigation. She is an associate professor at the Jesuit University of Madrid. And she's also an active member of the UIA Arbitration Commission. So again, in very good hands. We are very much interested to hear from you, Elena. Thank you.
Thank you very much, Veit. Here it is. So yes, I'll be talking about the effects of sanctions in general in arbitral proceedings, but specifically about Russian sanctions. So very generally, there are four wide groups of issues which may arise during an arbitration deriving from sanctions. So the first group are substantive issues, that is, the kind of disputes that can arise from sanctions, which can in turn lead to an arbitration. Then the second group of issues are jurisdictional issues, which is whether an arbitrator has the power to decide on matters relating to sanctions. Third group of issues are procedural issues. These are the procedural hurdles that may arise during arbitration proceedings. For instance, whether the counsel or the arbitrators will need a license. And the fourth group of issues are the enforcement issues. That is, once the arbitration is over, will the winner be able to enforce the award in order to effectively receive the sums awarded? So I'll treat them separately, and I'll start with the substantive issues. Now, the substantive issues which may arise really depend on the type of arbitration we're talking about. If we're talking about commercial arbitrations, the disputes that may arise are those that Maria Elena has already talked about. So that would be force majeure, it would be hardship, etc. So these hurdles would apply instinctively before the court and before an arbitration with very few particularities. But where you can find some disputes which arise specifically from sanctions is in investment arbitration. Let me give you an example. Canada and Russia signed a bilateral investment treaty in the 1990s, which specifically prohibits expropriations and guarantees certain rights in favor of the investors. So in 2022, last year, Canada has imposed sanctions which include asset freezes of designated Russian individuals. So say that one of these Russian individuals holds assets in Canada. Can this investor claim that Canada has breached its obligations under the bilateral investment treaty? So these are matters which have arisen in the past with other investors, for example, Qatar Airways, and which may arise here. And here we can also have an added complexity, which is the fact that often these sanctions are not imposed by the host state itself, but rather by an international organization. That is the example that you can see in the slides right now. So say that the European Union imposes sanctions on Russia and a Russian investor decides to file a claim against Spain. Would Spain be liable before Russia? Now, there haven't been many disputes in this sense up to now, so we can't really give answers to this. But it is true that Russia currently has 75 bilateral investment treaties with different states, which include the United States, Ukraine itself, and many members of the European Union, Canada, etc. So it is possible that we might start to find these kinds of disputes arising from the sanctions imposed on Russia. So that's it as to substantive issues. I'll now move on to jurisdictional issues. And I think there are two main jurisdictional issues which may arise. The first one are issues of arbitrability. That is, there are certain matters which cannot be decided by arbitration. I'm thinking of criminal matters or matrimonial disputes, etc. So the question here is, can you decide over matters concerning sanctions? Now, the prevailing view in both literature and arbitration practice is that disputes involving sanctions can be decided by arbitrators. That is, they are arbitrable. However, there have been decisions by some courts, for instance, the Italian courts, establishing that this is a matter which is not arbitrable, and consequently only the Italian courts in this case would be competent to hear these cases. And the second jurisdictional issue, which is particularly relevant for these purposes, is the exclusive jurisdiction of Russian courts. Now, on 8 June 2020, Russia enacted federal law 171FZ, which is known as the Law on Protection of Sanctions. And this law effectively entitles Russian sanction parties, which are subject to arbitrations abroad, to file an anti-suit injunction before the Russian courts. And what Russian courts would then do is issue an order ordering the claimant in the arbitral proceedings to stop pursuing the proceedings or not initiate new proceedings. And in addition to this, if the claimant refuses to respect this order and decides to not to seize the international proceedings, then the Russian court can award damages to the sanctioned person up to the amount claimed in the arbitration. So if the claimant is claiming damages in the arbitration for $1 million US, then the Russian defendants can claim $1 million US before the Russian courts against the claimant, and thus the arbitration would effectively become moot. Now, there was a very relevant decision from the Russian Supreme Court last year, which interpreted this provision, and it established that Russian parties could apply to the Russian courts, and they didn't have to prove that they have actually suffered a denial of due process or of access to justice, but rather the mere fact that they're considered sanctioned parties is enough for them to request these anti-suit injunctions and to be entitled to these damages. So of course, this was very, very relevant. And it will be very relevant for enforcement issues, which we will see later. But before that, I'd like to talk about the procedural issues that may appear during the arbitration. Now, due to time constraints, I'm not going to go into much detail on this, but I would like to make two notes as regards the procedural issues. The first note is that all actors involved in an arbitration may be subject to sanctions. So it's not only the parties we're talking about, we're also talking about the arbitrators, the council, the institution itself. And we're also talking about other actors such as the experts, translators, witnesses, etc. So every single one of these actors may require a license to both A, act in the arbitration, and B, make or receive payments which are related to the arbitration. Now, as you can imagine, this may entail extra costs, but most importantly, very significant delays in the proceedings. And also it can hinder the management of the case by the council, for instance, gathering evidence or having interviews with potential witnesses who are located in a sanctioned country. And also, and this is my second point, in order to overcome these hurdles, the institutions play a very, very important role. When I say institutions, I'm talking about arbitral institutions. And they have developed specific compliance programs which will help the parties overcome all of these hurdles and also find out if sanctions actually apply, because sometimes it might not be that evident. And also they have the resources, the tools, and the contacts to avoid all of these issues and are particularly helpful in applying for sanctions. For instance, the LCIA obtained the general license in the UK, which allows it to receive payments from sanctioned parties in an arbitration. So these are the 2 points I wanted to make regarding procedural issues. And I think we can now move on to enforcement issues. Now, there are three big questions that we can ask ourselves regarding enforcement, because imagine we've overcome all of these issues and now we have the award. Will we actually be able to enforce it? If the answer is no, you probably don't want to start the arbitration. So the first question is, can I enforce an award against frozen assets? And the answer will greatly depend on the jurisdiction we're talking about. So for instance, in the US, as we recently saw with the enforcement of the decision in Crystal X versus Venezuela, the enforcement of awards affecting blocked assets will require a license from OFAC. And the situation is similar in the EU, which only provides for a general license in cases where the sanctioned party was not sanctioned when the arbitration was commenced. That said, there are other jurisdictions, such as Switzerland, which do allow the transfer of frozen assets if it's done pursuant to an arbitral award or a judicial decision. So that's the first question. The second question is, can the award debtor refuse the enforcement on the basis that the decision affected sanctions? So to answer this, we have to think about how sanctions are broadly regulated, and in general terms, the enforcement of, how enforcement is regulated, and in general terms, the enforcement of awards is regulated by the 1958 New York Convention, which has been ratified by 171 states to date. So it applies in the vast majority of the countries in the world. And Article 5 of the New York Convention provides for the grounds under which enforcement of an award can be refused. You can see sections of Article 5 in the slide right now. And there are many other grounds which allow for refusal of enforcement, but the relevant ones for these purposes are A, refusal when the subject matter is not arbitrable, B, when the award is contrary to public policy, and C, when the award has been set aside in the seat of the arbitration. Now, the reason for setting aside or annulling an award are very similar generally to those which apply to the refusal of enforcement of an award. So in general terms, we can conclude that a party can refuse the enforcement of an award if A, the subject matter is not arbitrable, or B, it's contrary to public policy, either under the laws of the place where you're seeking the enforcement or of the country where you intend to set aside the award. That is the law of the seat, which will generally be agreed by the parties, or if it's not agreed, it will be decided by the arbitrators. So, as we have seen, most jurisdictions consider that sanctions are arbitrable, so you probably won't be able to refuse the enforcement of the award under this ground, but there is still the ground of public policy. So the big question here is, are sanctions considered public policy? And there's no uniform answer to this question, but in general, the answer will be subject to two different elements. The first one being the relevant jurisdiction where we want to enforce the award or set aside the award, and how that jurisdiction interprets the concept of public policy. So for instance, the US has a very restrictive approach towards interpreting public policy, but this might not be the case in other jurisdictions. And the second element, which will be relevant to determine whether you can enforce the award or not, is who imposed the sanctions. So generally speaking, UN resolutions are considered public policy. So if an award does not give effect to a UN sanction, then the enforcement will likely be able to be refused. So the question here is, what happens with sanctions which are not imposed by the UN? Here, again, it will depend on the jurisdiction. So for instance, in the US, the courts have established that UN sanctions are considered public policy, but US sanctions are not considered public policy. Consequently, an award which does not give effect to a US sanction can still be enforced in the United States, whilst an award which does not give effect to a UN sanction will not be enforced. In the EU, however, they've taken a wider approach to public policy, and the Court of Justice of the European Union has stated that EU sanctions are considered public policy, and consequently this will affect the enforcement of the award. So that said, what happens in Russia? And here is when we move on to the third and final question. So how does law 171 affect the enforcement of the awards? Now, as I mentioned before, and I'm coming to an end, this law establishes that Russia does not recognize the jurisdiction of international tribunals as regards Russian sanctioned parties. So this raises two enforcement issues. The first one is, if most of defendants' assets are in Russia, the award creditor will probably not be able to forcibly enforce the award against defendants' assets. And the second one is, if the claimant has assets in Russia, then it is possible that the defendant will claim damages under Law 171, and consequently it will be able to enforce this decision by attaching the assets of the claimant in Russia. Now, of course, it is very important to bear all of these aspects in mind before starting an arbitration. First of all, it can increase the costs and delay the proceedings. But secondly, if you don't pay attention to these issues and if you don't decide on this before starting the arbitration, you might incur the costs of the arbitration and then end up having an award which is not enforceable in the places where the defendant has the assets. Consequently, it is extremely important that the parties bear these in mind before embarking in an arbitration. So that's it from me. Thank you very much for having me and for listening. And I'm, of course, open to any questions.
Thank you very much, Elena. So this was our last presentation. We promised at the beginning to try to deal with a couple of questions in the end. We have now are over the time, about almost 20 minutes, and we have so far only received one question. So that is sort of, in light of the timing, not bad. We will just try to deal with this one question, I suggest. So for those that have time to bear with us, and I can see that we still have 74 participants. So thank you for staying online and bearing with us. We have a question from Philip Correa, and he asks that whether for those groups operating in both the European Union and outside of the European Union, and which might do the assembly of products in countries like India or the UIA, which include components which are sanctioned in the EU, but not in these non-EU jurisdictions, what are your views in terms of potential risks for the parent company if this parent company is located in the European Union and buys final products from their subsidiaries in India or the UAE? So that's a question, and I saw that Mareike and Eliana have already sort of followed up on that question on the chat, that might be relevant or answered by several of our speakers. I'm wondering who wants to tackle this one. Please go ahead and raise your hand if you, or just simply start speaking if you would like to deal with that.
I think from my side, I could summarize. The risk is potential risk. It's 100% because all products assembled in another country that is not approved in EU, it's not authorized, in other words. So we need this approval to have these products inside, for instance, medical device. Otherwise, we need to legalize everything in the country and then send the permits for European countries. So all medical and pharmaceutical products must be approved before go to the market.
Thank you, Eliane, for that comment. Any other comments on that one?
I think maybe on a also more general note, if it doesn't concern medical products, basically the risk is more or less the same as when you have other providers who will provide you with goods or components that you want to import into the EU. It's always important today to make sure that your suppliers will respect the sanctions that apply to you. And therefore, it's important to have a functioning compliance system that will ensure this compliance with the sanctions. Therefore, if it's your affiliate, this obligation is even stronger because you do have this very strong connection to the company, and therefore it's important to make sure that you communicate to them what are the goods that are sanctioned, and you request for them the sanction compliance and documents this request in your archives that you have requested from all suppliers, that they agree to respect and to honor the European sanctions.
Thank you, Mareike. In light of timing and also of the fact that we have not received any other questions, just very nice comments from listeners. I'm just monitoring the chat because now there are messages coming in, but this seems to be all just thank you messages. That's great. Yeah, in light of the timing, then therefore we will conclude this session. You will find all our contact details at the UIA directory and online. So if there are any further questions, I'm sure that our speakers will also be happy to follow up on them separately. We wish you all the best and thank you for staying with us. In particular, also again, thank you to our excellent speakers for this very interesting and topical seminar. Thank you very much. Bye-bye.